Hello, Stephen Avery Project Land. Kathleen just posted her filing on her website. We will get the link posted in here for y'all so you can read it yourself. But I'm going live right now to read it. While I'm reading it, I won't be looking at your questions and comments. So just bear with me as I read through this. And here we go. Defendant's motion for leave to file. Defendant's reply to the state's response in opposition to defendant's motion for new trial. Defendant Stephen Avery, by his undersigned attorneys, hereby moves this honorable court for leave to file his reply to the state's response to his supplemental 974.06 motion. In support thereof, defendant states as follows. 1. This cause is before this court on remand from the Wisconsin Court of Appeals. 2. The Wisconsin Court of Appeals issued its remand order on February 25, 2019. In its remand order, the Wisconsin Court of Appeals ordered defendant to file his supplemental post-conviction motion within 14 days. 3. Defendant timely filed his supplemental post-conviction motion in this court on March 11, 2019. 4. The Wisconsin Court of Appeals February 25, 2019 remand order did not authorize the state to respond to defendant's supplemental post-conviction motion. 5. Without first seeking leave, the state filed an unauthorized and unsolicited response to defendant's post-conviction motion on March 29, 2019. 6. Defendant now seeks leave to reply to the state's unauthorized and unsolicited response because there are issues and matters of record raised by the state which defendant disputes. Defendant believes the correction of matters of record will aid this honorable court in resolving defendant's pending supplemental post-conviction motion. If this court denies defendant's motion for leave, this court should strike the state's response because it was unauthorized under the Court of Appeals February 25, 2019 order. 7. A copy of defendant's reply to the state's response is attached hereto as Exhibit 1. 8. This request is made in good faith and not for purposes of delay. Wherefore, defendant Stephen Avery respectfully requests this honorable court grant leave to reply to the state's response to his supplemental post-conviction motion. Respectfully submitted, Kathleen T. Zellner on April 11th, 2019. The next page starts with defendant's reply to the state's response in opposition to defendant's motion for new trial. Defendant Stephen Avery, by his undersigned attorneys, respectfully submits the following reply in support of his supplemental blah blah motion for post-conviction relief pursuant to the state's violation of Wisconsin statute blah blah and Youngblood versus Arizona. The state's procedural bar arguments are themselves barred under the doctrine of judicial estoppel. In its February 25, 2019 order granting Stephen Avery's motion to stay, appeal, and remand for proceedings in connection with his blah blah and Youngblood claims, the Wisconsin Court of Appeals expressly stated, quote, it desires a ruling on the merits, unquote. In contravention to the Court of Appeals directive, the state, in its response, largely ignores the merits of Mr. Avery's claims. Perplexingly, the state has opted to attack Mr. Avery's motion on primarily procedural grounds. And the little footnote says, Mr. Avery notes that nowhere in its February 25, 2019 remand order did the Court of Appeals also authorize the state's response to a supplemental post-conviction motion. For this reason, Mr. Avery moves the court for leave to file this response. Based upon the Court of Appeals directive for an adjudication on the merits, Mr. Avery respectfully asks this court to reject the state's procedural arguments. Indeed, the state, in its response, is asking this court to disobey the Court of Appeals orders by disposing of Mr. Avery's claims based upon purported procedural defects. If the state wished to challenge Mr. Avery's claims on procedural grounds, it should have appealed the Court of Appeals order to the Wisconsin Supreme Court. Instead, the Court of Appeals directive for an adjudication on the merits is properly considered law of the case, and the state's procedural arguments should be disposed of as beyond the scope of the remand order. State versus Moeck, or Moeck, M-O-E-C-K. Additionally, the state's procedural bar argument fails under the doctrine of judicial estoppel because the state previously encouraged Mr. Avery to pursue his claims related to the destroyed bone fragments, lest they become procedurally barred. The doctrine of judicial estoppel prevents a party from asserting a position in one legal proceeding that directly contradicts a position taken by that same party in an earlier proceeding. In Wisconsin, judicial estoppel, quote, precludes a party from asserting a position in a legal proceeding and then subsequently asserting an inconsistent position, unquote. And that's State v. Perry. In this case, the state argued in its January 29, 2019 response to Mr. Avery's motion to remand in the Wisconsin Court of Appeals that if Mr. Avery could establish a sufficient reason for failing to raise his claim, he could file a new Wisconsin statute blah blah motion. According to the state, the motion may be made at any time, and this is what's underlined. If Avery can establish a sufficient reason for failing to raise his claim in the motions currently under the review, the claim will not be barred. Clearly, the state was attempting to induce Mr. Avery to dismiss the pending appeal to pursue his blah blah claim, thereby, as the Court of Appeals observed, waiving any future review of the orders from which Mr. Avery has appealed. On appeal, the state clearly argued that the only procedural hurdle Mr. Avery need jump to bring his destruction of evidence claim was the, quote, sufficient reason, unquote, standard set forth in Escalona-Naranjo. Mr. Avery has submitted and renews his submission that the sufficient reason for which he could not raise his claim earlier is the state's concealment of Deputy Hawkins' September 20, 2011 report and the updated evidence disposition ledgers that reflected the state's return of human bone fragments located in the gravel pit to the Hallback family. Notably, the state did not argue that Mr. Avery would be procedurally barred because he had not raised this claim in a motion before the Court of Appeals. Now, the state argues Mr. Avery's claim is procedurally barred, not because he has not articulated a sufficient reason for not raising it in his prior motions, but because he did not raise it in a prior motion before the Court of Appeals. This argument runs directly contrary to the state's prior position. Therefore, the state's recent contradictory argument triggers the doctrine of judicial estoppel because it argues a position wholly incompatible with its prior argument, i.e., Mr. Avery's claim cannot both be cognizable with a showing why he could not raise it in a prior motion and barred because he did not raise it before the Court of Appeals during the pendency of this appeal. For this reason, Mr. Avery respectfully asks this court to reject the state's internally inconsistent argument for the procedural preclusion of Mr. Avery's claims. Notably, the Court of Appeals order recognizes the duality implicit in the state's argument. Due to this case's extensive history, there is a benefit to having existing claims developed or litigated while they are relatively fresh, rather than positioning the claims to be procedurally barred in a future proceeding. The Court of Appeals recognized that this is the proper time and forum for Mr. Avery's claims. It would be manifestly erroneous to dismiss them on procedural grounds. However, even the state's procedural arguments fail. For these reasons, Mr. Avery respectfully requests this court grant his supplemental motion and order an evidentiary hearing on the substantive issues. 2, the successive supplemental motion is not procedurally barred. And seeing somebody say, is it a yes or a no? We don't get a yes or a no yet. Sorry, as I'm continuing to read this. We're still waiting for the court to respond. This is just Kathleen's response to the state's response. The court is the one that says yes or no. So this does not give you a yes or a no. This is just Kathleen ripping into the state that them responding to her filing was not necessary. So I'll continue. The state argues Mr. Avery's claim arising from Youngblood and Wisconsin statute blah blah are procedurally barred under state versus blah blah. In Escalano-Naranjo, the Wisconsin Supreme Court interpreted it to procedurally bar a defendant's grounds for relief if they have been finally adjudicated, waived, or not raised in a prior post-conviction motion, absent a showing of sufficient reason. In this case, the state first argues Mr. Avery's claims are barred because he failed to raise the issue of retesting the Manitowoc County gravel pit bones in his direct appeal and post-conviction motions. Here, the state misapprehends Mr. Avery's claims. In this post-conviction motion, Mr. Avery is not stating a sufficiency of evidence or ineffective assistance of counsel claim relating to inadequate testing of bone fragments. Rather, Mr. Avery's claims pertain to the constitutional violation stemming from the state's destruction of the human bone fragment evidence. The retesting of the bones is relevant to the constitutional claim on the matter of the exculpatory nature of the destroyed evidence. However, the retesting of the bone fragments is not a claim in its own rights. Therefore, notwithstanding the Court of Appeals directive to resolve Mr. Avery's claims on the merits that Mr. Avery did not raise a bone testing issue earlier does not preclude him from raising a constitutional destruction of evidence issue now. On this point, the state argues that Avery could have raised a claim regarding the destruction of bone fragments in the Court of Appeals in connection with the prior remand order. The state's argument fails for 2 reasons. 1, its premise is factually untrue. And 2, even if its premise were true, a prior motion to expand the scope of a remand order is not cognizable as a, quote, prior post-conviction motion, unquote, as contemplated by the Wisconsin Supreme Court in Escalona-Naranjo. First, the state's rendition of events is factually inaccurate. Neither Mr. Avery nor his current post-conviction attorneys received Deputy Hawkins' September 20, 2011 report until after December 17, 2018, thanks to Carol Ann Fitzgerald. The state's representation that it mailed the Hawkins report to Mr. Avery's private investigator on May 29, 2018, as part of a complete set of Calumet County Sheriff's Department reports is untrue. Indeed, although Mr. Kirby, acting as Mr. Avery's private investigator, remitted payment for the copying and shipping of the Sheriff Department's 1,117-page file, that file was never delivered to Mr. Kirby and therefore was never tendered to current post-conviction counsel. Specifically, In his affidavit, attached and incorporated herein as Exhibit A, Mr. Kirby avers he received one package from the Calumet County Sheriff's Department on May 30, 2018. Without first opening the package, Mr. Kirby delivered it to the law offices of Kathleen T. Zellner and Associates. Mr. Kirby did not see the contents of the package. In addition to paying for the 1,117-page report, Mr. Kirby paid for the copying and shipping of the Sheriff's Department 62-page post-conviction investigation report. Mr. Kirby viewed the Sheriff's Department's May 29, 2018 transmittal letter for the first time after the state attached it as Exhibit 3 to their response to Mr. Avery's supplemental blah blah motion. Mr. Kirby noted that, unlike letters he had received from the Sheriff's Department before, this letter was unsigned by Sheriff Ott and appeared to have been copied from a 3-ring binder. Indeed, the package Mr. Kirby delivered to current post-conviction counsel's office did not contain the Deputy Hawkins report or the 1,117-page investigation report the state alleges it delivered. In his affidavit, attached and incorporated herein as Exhibit B, current post-conviction counsel's law clerk, Kurt Kingler, avers when he opened the package Mr. Kirby delivered, it contained only the 64-page post-conviction investigation document. Further, the package did not contain the cover letter attached to the state's response as Exhibit 3. Further, the state's contention that current post-conviction counsel acknowledged receiving the investigative reports on or about May 30, 2018 in Mr. Avery's motion to compel, produced of recent examination of the DASI computer, and I will say Bobby computer, filed July 3, 2018, misstates the record. Specifically, a paragraph 2 of that document states, and then before I get to that, the footnote on this page says, it bears noting that while the pages of this document are numbered 1 through 63, the document contains 64 pages. The second and third pages are both numbered 2, and numbering continues sequentially, therefore, i.e. the fourth page is numbered 3, and so on. All right, here's the quote. On May 30, 2018, current post-conviction counsel's investigator, James Kirby, pursuant to the Freedom of Information Act, FOIA, received 64 pages of new reports pertaining to a follow-up investigation regarding several allegations or questions raised in several filings of Stephen Avery's current defense attorney, Kathleen Zellner, from the Calumet County Sheriff's Department. This statement supports the fact that Mr. Avery received the 64-page post-conviction investigation report. However, the state's argument that it indicates Mr. Avery received the 1,117-page complete investigative file is a non sequitur, i.e., it does not follow that because Mr. Avery received the 64-page report, he have not received the 1,117-page report. Therefore, because the state did not send to Mr. Avery's current post-conviction counsel Deputy Hawkins report on May 29, 2018, it cannot make the argument that Mr. Avery waived claims related thereto when he did not raise them in his next motion for remand order in the Wisconsin Court of Appeals. Because there was no opportunity for Mr. Avery to raise claims related to the destruction of human bone fragment evidence until after December 17, 2018. Thanks, Carol Ann Fitzgerald. Mr. Avery is not procedurally barred from raising them in the instant motion. It bears noting the reason Mr. Avery could not raise a claim related to the destruction of bone fragment evidence earlier was the state's continued withholding of Deputy Hawkins' September 20, 2011 report. Indeed, the state's attachment of Deputy Hawkins' September 9, 2011 report as Exhibit 2 to its reply constitutes the first and only time it is tendered the same to Mr. Avery. Further, even if arguendo, the state had produced Deputy Hawkins' report on May 29, 2018, that Mr. Avery did not raise claims related to the destruction of bone fragment evidence in his next filing in the Wisconsin Court of Appeal does not preclude him from raising it now. After a diligent review of Wisconsin's jurisprudence, Mr. Avery submits no Wisconsin court has concluded motions to remand, and by extension, supplemental post-conviction motions limited in scope to the remand order in the Wisconsin Court of Appeals are cognizable as, quote, prior post-conviction motions, unquote, as contemplated by the Wisconsin Supreme Court in Escalona Naranjo. Indeed, the state cites no authority for the proposition that anything but a defendant's failure to raise claims in 1, a prior post-conviction motion in the trial court, or 2, their direct appeal serves as a waiver of that claim. See example, State versus Bullock, blah, 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 blah. Therefore, even if the state did tender Deputy Hawkins' September 20, 2011 report to current post-conviction counsel on May 29, 2018, that Mr. Avery did not raise his destruction of evidence claims as a motion to expand the scope of the Wisconsin Court of Appeals remand order should not bar it from consideration now. Because Mr. Avery's claims, gosh, I thought I turned my sound off, sorry. Sound off. There. Because Mr. Avery's claims could not have been raised earlier, it cannot be barred by Escalona Naranjo. And let me take a drink of water here. We're going on to page 10 of 68. So just so you know where I'm at here in this filing. Moreover, the state's argument cuts against the Wisconsin Supreme Court's recalibration of the Brady Doctrine in State versus Wierski. In Wierski, the Wisconsin Supreme Court corrected the course of Wisconsin's Brady jurisprudence to focus on the state's misconduct instead of the defense's due diligence. In this case, the state's argument related to bone fragments returned to the Hallback family smacks of precisely the prosecution practices the Wisconsin Supreme Court condemned in Wierski. The state has repeatedly concealed and withheld evidence related to the return of bone fragments, e.g. the Deputy Hawkins report and updated evidence disposition logs, and then blame Mr. Avery for not raising claims related thereto. The state is engaging in a course of conduct proscribed by the United States and Wisconsin Supreme Courts. The state should not now be rewarded for engaging in this pattern of conduct. Mr. Avery's claims deserves a hearing on its merits. 3. Mr. Avery's supplemental motion is properly raised under 974.06. In its reply, the state argues that Mr. Avery's Youngblood claim lacks merit because it lacks valid constitutional or jurisdictional basis. The state's argument stands on the following premises. 1, a petition under Wisconsin statute blah blah is limited to jurisdictional and constitutional issues. And 2, following DA's office versus Osborne, there is no constitutional due process right to the preservation of forensic evidence. For the following reasons, both premises fail. Without legs, the station's argument cannot stand. First, the state argues blah blah applies only to jurisdictional and constitutional claims. In support thereof, the state cites State versus Baylett. Baylett, for its part, borrows the relevant language from State versus Allen. which in turn paraphrases Wisconsin Statute 974.06. Thus, the Baylett reasoning on the scope of blah blah jurisdiction is rooted in the statutory language itself. As for Nickel, the Court of Appeals comment that a blah blah motion is limited to constitutional and jurisdictional challenges is in dicta and is made without reference to any authority. In any case, Mr. Avery respectfully submits Nickel misstates the law. Indeed, the court could look to the scope provision the Wisconsin legislator wrote into blah blah. In relevant part, blah blah states as follows. After the time of appeal or post-conviction remedy has expired, a person in custody under sentence of a court claiming the right to be released upon the ground that the sentence was imposed in violation of the U.S. Constitution or the Constitution or the laws of this state may move the court which imposed the sentence to vacate, set aside, or correct the sentence. Clearly, claims arising under Wisconsin statutes are cognizable under blah blah. Regardless, Mr. Avery's Youngblood claim related to the destruction of human bones from the Manitowoc County gravel pit is cognizable under blah blah because it is constitutional in nature. On this point, the state argues Youngblood and its progeny do not apply to post-conviction proceedings. Here, the state's argument wholly ignores the state of the law in Wisconsin. Post-conviction defendants have a due process of liberty interest in the post-trial destruction of evidence. The Parker Court adopted the due process destruction of evidence test set forth in State versus Noble. Noble, in turn, reiterates the destruction of evidence due process test in State versus Greenwald. Blah, blah, blah. So citing more cases. Thus, there is a cognizable due process right to the preservation of evidence post-conviction. Wisconsin courts have recognized the constitutional dimension of the state's failure to potentially exculpatory DNA evidence. Post note at the bottom says, Mr. Avery notes in line with the United States Supreme Court reasoning in Osborne. Okay, so back to Kathleen. Here, the state violated Mr. Avery's due process right to the post-conviction preservation of potentially exculpatory evidence. As previously stated and in line with the Court of Appeals directive, this claim deserves to be heard on its merits. It is important to note that Osborne involved a civil rights claim under blah blah, asserting a federal constitutional due process right to access evidence for DNA testing. It was into this context the Supreme Court held the post-conviction preservation of DNA evidence is not protected due process right. Indeed, the Supreme Court consistently criticized Osborne for failing to request the sought-after evidence in state court. Blah, 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 blah. Scrolling down, trying to shorten this how I can. Mr. Avery, not wanting to stand in Osborne's shoes, now marshals state law post-conviction remedies, including remedies related to the destruction of apparently exculpatory or potentially exculpatory human bone evidence from the Manitowoc County gravel pit. In so doing, Mr. Avery relies upon the due process right to post-conviction preservation of evidence conferred in Parker. This reliance is not at odds with Osborne. Rather, it is the exercise of Osborne's broadest holding. The states should retain the authority to extend due process liberty interests to a criminal defendant after conviction. Because blah blah expressly contemplates claims arising under Wisconsin statutes, and because post-conviction destruction of evidence claims are cognizable due process claims in Wisconsin, Mr. Avery has stated a cognizable claim for relief under blah blah. 4. Mr. Avery, having stated a cognizable claim for relief under blah blah, has met his pleading burden. The state next argues that Mr. Avery has not sufficiently pled his post-conviction destruction of evidence claim because the bone fragment evidence is, according to the state, neither apparently nor potentially exculpatory. Here, the state makes a fatal error in its argument. It conflates Mr. Avery's burden to show that the testing of the destroyed bone fragments was exculpatory, either 1, apparently exculpatory, or 2, potentially exculpatory, and the destruction was made in bad faith, with the burden Mr. Avery would face were he making a claim of third-party liability under Denny. The state is plainly misstating Mr. Avery's argument. Mr. Avery's destruction of evidence claim is not a third-party liability claim. Indeed, nowhere is the burden to show the identity or the true perpetrator imposed upon Mr. Avery. Mr. Avery need only marshal evidence demonstrating the testing of now destroyed evidence was 1, apparently exculpatory, or 2, potentially exculpatory, and the destruction was made in bad faith. Quote, exculpatory evidence is evidence the suppression of which would undermine confidence in the verdict. United States versus Ruiz. Thus, Mr. Avery's burden is to explain why the evidence undermines confidence in the verdict, not prove someone else's guilt. Aha. The state is arguing that it is Mr. Avery's burden not only to present substantial evidence in supporting of his innocence, but also show that someone else perpetuated the crime of his conviction. These burdens are far from the same. By way of analogy, the state's argument is akin to requiring a criminal defendant convicted on disputed DNA evidence to show not that the DNA excludes them, but prove whose DNA it really is. Such a burden cannot be imposed here. The destroyed bone evidence was apparently exculpatory or potentially exculpatory. Next, the state argues, in the context of its misguided Denny third-party liability argument, that the bone fragments were neither apparently nor potentially exculpatory. Additionally, the state argues, quote, there are many fragments from the quarry that may or may not be human still in evidence available for testing, unquote. The state's argument misses the point. Mr. Avery's claim concerns the testing of human bone fragments from the gravel pits to adduce their identity and demonstrate that the evidence was not, as the evidence argued at trial, concentrated around Mr. Avery such that he was the sole suspect. Indeed, Mr. Avery's claim concerns destroyed bone fragments, and this section's underlined, identified as human by Dr. Leslie Eisenberg. These bones are listed as Exhibit 10 to Mr. Avery's supplemental motion. We are now on page 16 of 68. The skeletal remains contained in this table that can be reliably traced to the gravel pits are blah, 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 blah. Without exception is underlined. Every one of these items was returned to the Hallback family. There is no comparable evidence now available to Mr. Avery for testing because there are no human skeletal remains recovered from the gravel pit preserved in state custody. The state limits its argument to blah, blah, the 8, 6, 7, 5, the pelvic bone fragments, Dr. Eisenberg classified as possible human, which Dr. Stephen Symes has, based upon his examination of the forensic anthropology photographs, confirmed were human. This choice is perplexing because Mr. Avery's claims concern all, is underlined, human bone fragments recovered from the Manitowoc County gravel pit, then returned to the Hallback family in September 2011. Dr. Eisenberg, without qualification or evocation, blah, blah, I'm getting tongue-tied, identified as human numbers, blah, 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 blah. For the state to now argue that Mr. Avery's claim fails because he has made no showing that the bones were human is disingenuous and mistakes Mr. Avery's argument. First, the state's argument is disingenuous because it is beyond argument that numbers, blah, 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 were human in origin. It is past time for the state to credit the conclusions of its own expert. Second, evidence of the identity, as opposed to the species of the bones, tends to prove Mr. Avery was not the perpetrator of Ms. Hallback's murder, because if the bones were identified as Ms. Hallback, her murder, mutilation, and the disposal of her remains did not occur in a location tied exclusively to Mr. Avery. Footnote. Throughout its response, the state refers to the origin of the bones as the Radant Quarry. Based upon Mr. Radant's statements and plat maps maintained by the Manitowoc County Recorder of Deeds, the property on which bone fragments were located belonged to Manitowoc County and operated as a gravel pit. Back to Kathleen. No reasonable trier of fact could conclude that if Mr. Avery murdered and mutilated Ms. Hallback in the Manitowoc County gravel pit, he would move her bones from the gravel pit to his own burn pit and thereby incriminate himself. The evidence should be considered in light of the opinions of Dr. DeHaan, who, to a reasonable degree of certainty in the field of fire forensics, has concluded Mr. Avery's burn pit was not the primary burn location. Thus, it is reasonable to conclude the gravel pit was the primary burn site. This evidence, therefore, tends to show the murder, mutilation, and destruction of Ms. Hallback's remains did not occur, as the state argued at trial, in locations controlled exclusively by Mr. Avery. This evidence is exculpatory of Mr. Avery because it undermines confidence in the verdict. In the words of one of Mr. Avery's trial attorneys, Jerome Buting, quote, "If that body was burned somewhere and then moved and dumped on Mr. Avery's burn pit, then Stephen Avery is not guilty, plain and simple. Now that is why the state has gone to such trouble avoiding the fact that the bones were moved. That's why you heard nothing about it here, because it does not fit with their theory that Avery is guilty," unquote. While the jury at Mr. Avery's trial rejected Buting's argument, it did not have the benefit of hearing evidence that the bone fragments later returned to the Hallback family were originally located in the Manitowoc County gravel pit and were unwavering identified by Dr. Eisenberg as human. This, coupled with the other incriminating evidence linking the Manitowoc County gravel pit to the crime scene, significantly undermines confidence in Mr. Avery's verdict, because no reasonable trier of fact could have concluded, considering this significant evidence pointing away from Mr. Avery, that Mr. Avery is guilty beyond a reasonable doubt. The state makes much of the Dassey burn barrel and its theory that Mr. Avery placed the bones in the gravel pit to evade detection. This theory ignores Dr. DeHaan's scientific opinion that Ms. Hallback was not burned in Mr. Avery's burn pit. As previously stated, the notion that Mr. Avery would burn Ms. Hallback's body at some location other than his burn pit, then transfer her remains there, defies logic, because it is logically unsound and because it stands against the weight of Dr. DeHaan's opinions. The state's theory should be rejected. For these reasons, Mr. Avery has sufficiently pled the apparent or potential exculpatory value of the destroyed bone evidence. 2. The bones were destroyed in bad faith. Next, the state argues that it did not act in bad faith when it released the bone fragments to the Hallback family. In support thereof, the state argues that it undertook reasonable efforts to test 8, 6, 7, 5 before Mr. Avery's trial, and that it was justified in destroying the bones because they were not an issue in Mr. Avery's direct appeal. Footnote: Mr. Avery shall refer to page numbers in the header as applied by the court. We're now going on page 19 of 68. We're not even halfway there. All the blah, blah, whatever I say blah, blah, is when it's saying numbers of prior court cases that it's referring to, that I'm just getting to the other stuff. And thank you, Jane. I see you answered that. And also for people asking, is it a yes or no? This is just Kathleen's response to the state. We're still waiting for the court to do yes or no. And Josh, who's asking, when can we get a copy of this filing? It should be posted. A moderator from Stephen Avery Project is posting the link to this while I'm reading it for people who don't have access to read it. So now I will continue with reading. And yes, it's also on Kathleen's website. That's where I'm reading it from. All right. So in so arguing, the state wholly ignores the trial court's April 4th, 2007 DNA evidence preservation order and the duty to preserve evidence imposed by blah, blah. As for the April 4, 2007 preservation order, the state was on notice that forensic evidence collected in this case should be preserved for future testing by Mr. Avery at any time. That the order expressly contemplates only blood evidence is not dispositive. The parties have construed the order to cover the testing of skeletal remains, a bullet fragment, and the swab taken from the RAV4 hood latch. The sweaty sweat. It should also be understood to cover human skeletal remains from the gravel pit. Further, the state demonstrated in its awareness of Wisconsin's forensic evidence preservation statute, blah, blah, at trial. Special Prosecutor Gahn noted, quote, let's wait, parenthesis, to arrange the preservation of evidence, end bracket, under these proceedings, until these proceedings are over, because Wisconsin does have a mandatory preservation statute that would be applicable in this case, unquote. Mr. Avery submits this recognition confirms his contention that the state knowingly violated the preservation statute when it returned human skeletal remains from the gravel pit to the Hallback family in September 2011. That is, the state knew it had a duty to preserve the evidence or, prior to destroying it, notify Mr. Avery and his attorneys. Yet, it did neither. This knowing deviation from its duty under the law confirms the state acted in bad faith when it destroyed the human bones from the gravel pit. It bears noting the Assistant Attorney General Fallon and Special Prosecutor Gahn, both of whom represent the state in this proceeding, were the state attorneys who participated in the return of human bones from the gravel pit to the Hallback family. They are interested parties, and their bad faith is directly at issue in this case. Their protestations and denials are therefore suspect. The court must discern whether their arguments themselves are made in good faith or in the simple interest of self-preservation. Given the manifest weight of the evidence and the arguments offered by the state, Mr. Avery suspects the latter is true. Water. After all, the upshot of Mr. Fallon and Mr. Gahn's arguments is that they reawakened the Hallback family's grief in 2011 to give them animal bones. I can't. Further, Mr. Avery has alleged sufficient material facts in support of his destruction of evidence claim to secure a post-conviction hearing. State versus Allen. As for who, Mr. Avery has alleged Wiegert, Deputy Hawkins, Assistant Attorney General Fallon, and Special Prosecutor Gahn destroyed every human bone recovered from the gravel pit by returning them to the Hallback family. As for what, Mr. Avery has alleged the bones were identified as human by Dr. Eisenberg and were recovered from multiple locations in the Manitowoc County gravel pit. As for where, Mr. Avery has provided this court with the exact location of the human bones recovered in the Manitowoc County gravel pit. As for when, Mr. Avery has alleged the human bones from the gravel pit were returned to the Hallback family on or after September 20, 2011, during the pendency of his direct appeal. As for why Mr. Avery has alleged he is entitled to relief on his claim because the state violated his due process rights, extended to post-conviction proceedings in Parker, to the preservation of apparently or materially exculpatory evidence, and the state acted in bad faith in so doing. As to how Mr. Avery has alleged inter alia facts supporting his contentions that the destroyed bone evidence was, in fact, exculpatory, and the state acted in bad faith in destroying them. Each of these facts substantiates Mr. Avery's destroyed evidence claim. Because each of these facts has been sufficiently pled, Mr. Avery has stated a cognizable claim for relief under the framework of Trombetta and Youngblood. 5. The state violated Wisconsin statute, blah, blah. The state argues that the human bone fragments from the gravel pit were not subject to preservation under Wisconsin statute, blah, blah, blah. The state correctly notes that blah, blah protects biological material from the victim or that may reasonably be used to incriminate or exculpate any person for the offense. However, the state makes its first misstep when it equates the evidentiary value of human bones located in Mr. Avery's burn pit or the Dassey burn barrel with human bones located in the Manitowoc County gravel pit. The location from where the human bones were recovered is the key, the word key, magic key, to their evidentiary value. Additionally, the state never ascertained the identity of any of the human bones from the gravel pit. Now, by the state's actions, their identity may never be ascertained. Thus, no comparable evidentiary material is available to Mr. Avery. Additionally, Mr. Avery is not positing, blah, blah, should be interpreted as a mandate to preserve every single piece of biological evidence recovered during an investigation. Indeed, Mr. Avery is simply positing that the state should comply with Wisconsin law when considering the preservation of evidence that may reasonably be used to exculpate someone. In this case, as described herein and in Mr. Avery's March 11, 2019 supplemental blah, blah motion, the human bones recovered from the gravel pit may reasonably be used to exculpate Mr. Avery because they undermine confidence in the verdict, and the evidence, if tested, could reasonably prove Mr. Avery's innocence. Here again, the state contends, quote, none of the bone fragments recovered from locations in the quarry were positively identified as human, unquote. This allegation is patently untrue. Without qualification or equivocation, Dr. Eisenberg, the state's own expert, identified as humans, numbers, blah, 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 as human, blah, 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 the bones. The state had a statutory obligation to preserve the evidence because the human bones from the gravel pit, if determined to be Ms. Hallback, would prove Mr. Avery innocent. As described herein, proof that Ms. Hallback was murdered or mutilated in an area outside Mr. Avery's control proves his defense that her remains were planted in his burn pit and, therefore, his innocence. Thus, even if the human bones from the gravel pit were not subject to preservation because they were identified as Ms. Hallback, they were subject to preservation because they were reasonably likely to exculpate Mr. Avery. 6, the state's argument relies on stale resources and misrepresents the validated and accepted capabilities of rapid DNA identification technology. We are now going on to page 23 of 68. The long and short is this is just Kathleen's response to the state saying the state had no reason to reply to her filing in the first place, and she's showing again how they have covered up these bones that prove Stephen is innocent. All right. So continuing on with page 23 of 68. Lastly, the state argues that because rapid DNA technology, quote, is not authorized or approved for forensic use, unquote, this court should not entertain Mr. Avery's argument that rapid DNA identification analysis could have, to a reasonable degree of certainty, yielded probative evidence of the identity of the gravel pit bones. In support thereof, the state contends such a forensic application is beyond the scope of the Rapid DNA Act. The state relies on stale standards and inappropriate policy positions. Specifically, the state conflates the scope of the Rapid DNA Act with the universe of applications in which rapid DNA technology has been successfully used. This argument is fallacious and reductive. It wholly discounts the development, validation, and widespread acceptance achieved by the system in forensic application in recent years. The successful iteration of the Rapid DNA Act was introduced by United States Representative Jim Sensenbrenner, Republican, Wisconsin, on January 12, 2017. It is notable that the language of the Rapid DNA Act did not change from its first introduction in the House on January 13, 2015. That is, the 2017 Rapid DNA Act is composed of language that reflects the state of rapid DNA technology in January 2015. For its part, the 2017 Rapid DNA Act was enacted to authorize law enforcement agencies to use rapid DNA instruments to test arrestees upon booking at police stations to screen them for connection to other crimes before being released. Thus, the Act did not contemplate the universe of forensic applications for which rapid DNA analysis has been proven suitable in the 4 years since its initial introduction. Moreover, the language the state claims is specifically stated in the Act is, in fact, not contained in the Act. The quoted text, quote, at present, rapid DNA technology can only be used for identification purposes, not crime scene analysis, unquote, comes from the House Judiciary Committee's May 11, 2017 report. First, this quote is a simple statement of the focus of the Act, i.e., to identify suspects in the same way a fingerprint is used. It should not be read as a definitive delimitation of the usefulness of rapid DNA technology. Second, this report, like all is underlined, the persuasive authority marshaled by the state is fatally outdated. It states the capabilities of the technology before May 2017. The capabilities of rapid DNA technology have developed considerably since May 2017. As described in Dr. Richard Selden's second supplemental affidavit, attached and incorporated herein as Exhibit C. Rapid DNA identification technology has garnered widespread validation and acceptance in jurisdictions across the country for the analysis of crime scene samples. Specifically, the American Society of Crime Lab Directors, whose November 15, 2017 position paper the state cited, has recognized rapid DNA's usefulness in the field of disaster victim identification. Disaster victim identification using rapid DNA technology involves the analysis of degraded samples, far more complex than the single source identification samples referenced by the state. Clearly, the ASCLD's interest in rapid DNA technology for forensic samples has evolved, considering significant technical developments over. Oh, I see a Gilter has posted somewhere. Sorry, I can't deal with that right now. Significant technical developments over the past several years. Additionally, rapid DNA technology has been implemented in jurisdictions across the country to process forensic samples. On April 10, 2019, Kentucky Governor Matt Bevin announced that after months of careful consideration, his Commonwealth is using rapid DNA identification system in sexual assault investigations. As described by Dr. Selden, quote, sexual assault evidence kits contains among the most difficult of forensic samples. Vaginal swabs that contain a mixture of female epithelial cells and male sperm cells. These complex forensic samples can be processed on the ANDI system, unquote. And that is Exhibit C. In fall 2018, the Utah Attorney General announced that Utah has implemented the ANDI Rapid DNA system for the processing of forensic and crime scene examples. Indeed, the Attorney General, Sean Reyes, announced rapid DNA technology solved its first case within 1 week of its implementation. In that case, blood and other forensic samples were processed to identify a burglar. On February 11, 2019, the Office of the New York Chief Medical Examiner presented its work using the ANDI Rapid DNA Identification System to the American Academy of Forensic Sciences. The Chief Medical Examiner's Office reported its conclusion that rapid DNA analysis of bone samples was comparable to conventional laboratory methods and described 2 cases where the ANDI system was superior to conventional methods. The ANDI system generated DNA identifications from skeletal remains from the September 11, 2001 World Trade Center tragedy, which yielded no useful results when analyzed using conventional methods. Lastly, the Sacramento County Coroner recently published a paper describing her experience with and lauding the usefulness of ANDI Rapid DNA technology. Using ANDI Rapid DNA technology to identify victims in the campfire, the coroner successfully identified no less than 85% of the human remains from the campfire. This accomplishment is notable because many of these bone samples were severely degraded by fire, just as the skeletal remains recovered by the Manitowoc County gravel pit were. Thus, the successful implementation of ANDI Rapid DNA technology in the aftermath of the 2018 California wildfires directly supports the applicability of ANDI Rapid DNA technology in the case. The state's conclusion that, quote, rapid DNA testing is not ready for crime scenes, unquote, relies on stale sources and is ignorant of that technology's development in recent years. While there is a, quote, huge difference between fresh buccal samples and 14-year-old charred and calcined bone fragments, unquote, ANDI Rapid DNA technology is equipped to process 14-year-old charred and calcined bone fragments. That the state has chosen to ignore the multitude of supporting examples referenced by Dr. Selden and instead selectively rely on outdated policy statements does not change this fact. Conclusion. For the above stated reasons, Mr. Avery requests this court grant his supplemental blah blah motion, set his cause for a new trial, reverse his conviction, or grant any other relief this court deems appropriate. Dated April 11, 2019. So the next one is an affidavit of James R. Kirby. He is a private detective located, and he's licensed in Illinois, Indiana, and Wisconsin. He did the FOIA. He asked for reports generated between October 31, 2005 and April 19, 2018. On April 20, 2018, the Calumet County Sheriff's Department responded to my FOIA request. The Sheriff's Department informed me that it would provide the complete investigative report consisting of 1,117 pages for a copy fee of $279.25 plus shipping costs. I paid the copy fee. The Sheriff's Department contacted me again on May 18, 2018, informing me it would also release the 63-page post-conviction investigative report for an additional fee. I paid the additional fee and shipping costs. On May 30, 2018, I received one package from the Calumet County Sheriff's Office. Without opening the package, I delivered it to the law offices of Kathleen T. Zellner and Associates, PC. At no time did I see the contents of the package. I have been shown the letter that was attached as the state's Exhibit 3 to its response. Unlike other letters I received on prior FOIA requests from Calumet County Sheriff's Department, attached in his Exhibit A, this letter was unsigned by Sheriff Marcotte and appears to have been copied from a 3-ring binder. At no time on May 30, 2018, did I receive documents responsive to my April 19, 2018 FOIA request to the Calumet County Sheriff's Department. And then it's signed by James R. Kirby, was on April 2nd, 2019. Next one is on Calumet County Sheriff's Department letterhead, and is to James Kirby. And this is receipt of his $279 payment. The thing that's in bold says the Calumet County Sheriff's Department will also release the post-conviction investigative report, which consists of 63 pages at 25 cents per page for a total cost of $15.75. The shipping costs for all records totaled $15.83. Upon receipt of payment totaling $31.58, these records will be mailed to you at the above listed address. And that was dated May 18th, 2018. Next page is also on Calumet County Sheriff's Department letterhead, as April 20th, 2018 to Kirby. The section in bold says $279.25 at 25 cents per page plus shipping costs. Next one is also Calumet County Sheriff's Department on February 27, 2017 to Kirby. And this is, please accept this correspondence as the Calumet County Sheriff's Department response to your public records request dated February 20, 2017, wherein you requested a copy of a recording taken of a voicemail message from an answering machine at the residence of 4433 County Road B, Manitowoc, Wisconsin. As referenced in the Sheriff's Department policy report, the recording was copied by Detective Jacobs on the Manitowoc County Sheriff's Department. Blah, blah, blah. On page 35 of 68 is affidavit of Kurt Kingler, where he says he's a law clerk of Kathleen's since July 2015. He is a law student from Loyola University, Chicago School of Law. He delivered James Kirby, and so he's saying James Kirby delivered that. He opened the package to examine the contents. Inside the package were 64 pages of the Calumet County Sheriff's Department investigative reports. There was no cover letter. He scanned the 64 pages, and it is signed on April 11th. Page 37 is a second supplemental affidavit of Richard F. Selden, MD, PhD. And so he's talking about the rapid DNA. So it's just going over all the goods and the bad on the rapid DNA that we've gone over and all the cases where it's been used. So we don't need to read through that. So page 45 of 68. Oh, this is just listing all of Dr. Selden's accolades. Scrolling. Still scrolling through his accolades. Page 55 of 68 is an article from Bipartisan Rapid DNA Passes in the House of Representatives. This is that Jim Sensenbrenner, who represents Wisconsin's 5th District. We're not reading that. You can read it yourself if you want. Article. All right. So then that's everything. That's the whole thing in her, in the filing today. So to summarize, all she's doing is responding to the state's response, saying that the state had no legal reason to respond. We're still waiting for the court to rule. So this doesn't tell us if court or if Stephen gets a new trial, is he being released, any of that. We have to wait for the court to decide what's happening there. So this is just Kathleen's rebuttal to the state's rebuttal, where she is again just going over that they said those bones in the Manitowoc gravel pit, and don't get it confused. There's two. There's salvage yard, there's a Red Ant quarry, there's the Manitowoc gravel pit. Manitowoc gravel pit is where 8675 was, and that Sweaty Sweat said, these aren't the droids you're looking for. Don't pay attention to any bones that were found in the gravel pit. Not going to spend any time talking about this. This is nothing. But anything that was found at that gravel pit in all the legal proceedings that have taken place over all these years said that was to remain in evidence, to be used if testing came about that could tell you what these bones were. Are they animal? Are they human? Are they Teresa? Is it Carmen Bootwell? What are these bones? Always been agreed upon. But then for some reason in 2011, and now remember, this case was 2005, 2006. So in 2011, they then give these bones to the Hallback family, deliver the bones to a funeral home. So now those bones are lost, because even if they buried the bones, you've broken the chain of custody, you've mixed them up with other bones. So you've now made it so Stephen can't use that evidence, so therefore he can't be given a fair trial. So, and the state would claim that they knew nothing about this, but when you see that when they gave these bones to the Hallback family, all the players, the usual suspects, were involved. So they knew those bones were given to the Hallback family and said nothing. And when Kathleen took the case and they gave her evidence, they gave her the documents and all that stuff, they didn't include the report when that deputy signed out the bones to Uyghur. It wasn't until people were FOIAing stuff, and then Carol Ann Fitzgerald saw it, and then she messaged Kathleen as a, just in case you didn't see this, did you know this? And that's major. So, and then they're also trying to knock the rapid DNA testing that Kathleen had talked about that can literally tell you what those bones are in 2 hours. And they were trying to discredit that, like that rapid DNA testing is nothing. And so this filing today is showing how it's not nothing, and showing you how that, that rapid DNA testing has been used in multiple cases and could have helped in this one, but now you can't do it. So that's the summary of today. It's still the same thing that that she's been going for, that they gave these bones to the Hallback family in 2011 that was to remain in evidence. And if those bones is Teresa, then that proves Stephen's innocence, because nowhere in Sweaty Sweat's theory on how Stephen allegedly committed this crime did Stephen leave the salvage yard. And he fought tooth and nail to claim that Stephen never did. when there were people that had said they had seen him at the gas station or whatever. No. He always stayed. He never left there. Well, this is showing that Teresa's pelvic bone is at the Manitowoc Quarry, whom the state's own expert, Dr. Eisenberg, stated that as a human bone. So it's all a whole lot of shadiness and deception going on there. So this video of me reading all of this will remain up here. So yes, I know not everybody got to see it now. I believe, we also have the link to it for you to read it for yourself if you because I know sometimes people can't truly understand it if somebody else is reading it to them and they need to read it for themselves. So we have it posted, and you can also read it on Kathleen's website. It's listed up there. So, and we're still just waiting for the court to respond. I don't know if the court has unlimited time to respond, or if there's always that 30 days or 60 days or 90 days. So I'm not sure how long, till we hear something. But as soon as we do, we'll post it. We'll get it to you immediately. And I have, and just to end this, I have been added to Stephen's visitors list. So I am going to see him in the next week. So after I visit with him, I will give you an update on how that visit went. So that's everything. So I'm going to end this now. We have another group called MAM Gossip. I will go live in MAM Gossip in like 45 minutes, so I won't read all this over again. We'll just discuss it more in depth like we do in MAM Gossip. So that's it for now. I thought this filing again, Kathleen, love her. She cracks me up. So, all right, I'm out of here for now. Until next time, see you on MAM Gossip today.